matter is being held by way of teleconference, any orders or directions made after or during the course of this hearing will be issued by the Registry in Dubai on His Excellency Justice Ali Al-Madhani's instructions. The hearing today is in the matter of CFI 055-2020 before His Excellency Justice Ali Al-Madhani. The applicant is represented by Zayed Al-Shamsi, advocates and legal consultants, and lead counsel is Helen Tung. The respondent is represented by Clyde & Co. and lead counsel is Sophia Hurst.
Well, again, good morning all.
Good morning.
Yes, we were expecting the defendant to appear on time.
I do apologize. So I had some technical difficulties. I do appreciate you and my colleagues waiting.
Say, and Mr. Hurst, we have you waiting for a long time as well. Okay, if there is any preliminary issues that we need to deal with before we start, maybe. Yeah.
Yes, thank you, sir. So just in relation to the bundle, I've had an opportunity to speak to my colleague from Clyde & Co. And we just want to make sure you've got everything in front of you. So there's the bundle, and then there were 4 attachments from my learned friend. Primarily, it's added onto the last email, which includes, I believe it's a correspondence, the response from our side on the 9th of August 2020. There's a case law that's been submitted. It's the
if you refer to any document, would you please give me the reference, like by letters or numbers, so I can see it if it's there or not?
Okay.
Judge, if it assists, if you're using the electronic bundle, I believe they have been all added. So you should have tabs A to Y, letter Y. If they haven't appeared, perhaps refresh the page. Mine have just popped up, so I hope everybody's got the same documents in front of them on the bundle.
Well, thank you. Yes, I do have up to the letter Y.
Perfect.
Reply Memo dated 9. Yes.
Sorry, sir, I just need to bring that up myself, so I do apologize. But then aside from that, I believe the bundle is agreed.
There is one outstanding matter on the bundle, Judge. I apologise for interrupting Ms. Tung, but there is an outstanding application by her client to adduce a further witness statement, which is opposed by my client. So we do object to that in the bundle as matters stand.
Yes, that's what I was about to introduce to you, to deal with it first.
Good morning.
Yes, sir. So would you like me to go straight into the application?
Yes, please.
Yes, sir. Thank you very much. So, sir, I should want to firstly thank the court and also my learned friends for assisting me in the matter. I was instructed quite late in the day. I should mention that I had the opportunity to take instructions as well, and to sort of promptly, as it were, with the assistance of the court, to make the application for the second witness statement and the medical, which I would like to share. So it is fundamental to the current application to set aside. If I may start, firstly, there are a number of documents which have been referred to or alerted to, for example, in the defence, the first witness statement of Mr. AJAY SETHI, and you will see also in the correspondences and in the running themes, the claimants and also the witness, the main witness, Mr. Santa, I think, would say. Serrano would say that there is no reason as to why there were any delays. And so the medical evidence provides exact reasoning as to what happened to Mr. Sethi, my client. You will see in the medical evidence, which if the court would permit, shows that from June, July, August, he had medical appointments, some of which were also taken with sedation, and thereafter, on October the 5th, he was actually diagnosed with COVID-19. I want to emphasize that the timing of events in a COVID-19 world, as it were, will allow you to understand the kind of mental, emotional distress that he was in, which is also referred to in the defense statement. You will appreciate that COVID-19 has changed the way things work. We have to wear gloves, masks. In fact, we're having this hearing purely because of COVID-19. He was diagnosed on the 5th. His wife was diagnosed on the 8th of October. And may I say this quite frankly, so nobody knows what will happen to the individual when they're diagnosed with COVID-19. If you're lucky, you survive. And that's the situation our client was in. If you're unlucky, you might die of COVID-19. So I don't want to exaggerate or undermine the seriousness of COVID-19 because the world is responding to it, as it were. So the evidence to be presented for court is fundamental because, and if I may be so blunt, sir, I would say, my learned friend might say, well, you're opening the floodgates to these kind of cases. Well, the reality is the floodgates are open because the argument of whether we are affected by COVID-19 or not is already there. The situation my client is in, the impact it had on him, whether he could function or not. I mean, to put it this way, sir, my learned friends would argue, why did Mr. Sethi delay in responding? Why did he not, put in the documents? Well, I would base it on his medical situation, sir, particularly if you have an outstanding medical situation. Contracting COVID-19 makes it that much more serious, sir. Those that have passed away from COVID-19 actually have preconditioned medical situations. So I'm not a doctor. I don't present myself as one, but I'm putting it in context of the situation we are currently in. It's not an ideal one, but to the extent of the question of why did he not respond, it's not one of deliberate neglect. It's not one of intent to waste the court's time. It's because he couldn't. He was not in a position to deal with the situation. And may I put it in context of also, he's a businessman, so he has a business to run. And obviously his family situation, his wife contracting, and he was living with his 3 daughters who were not COVID-19 positive. But obviously you can imagine the situation of having to deal with that. So I put that as a starting point of why this medical evidence needs to come in before you, sir, so that you can also make a fair finding. In relation to the detailed explanations, which, by the way, sir, I should mention was already in the defense, alerted in his witness statements, is a fleshed out version of, to provide the loan also in context. Because as you will see in the particulars of claim, it is a very straightforward loan repayment agreement. Unfortunately, my client's case is that it is not. And the evidence presented before you is also submitted. However, the second witness statement provides flesh to the bone, which would allow you to understand why. And again, I emphasize why not earlier is because he was not in a position sir, to provide such detail. As I would put it, sir, that it's a miracle that Mr. Sethi is alive, that he recovered and is able to provide this evidence, and he provided in detail. So I wish, sir, that you would see it as such. It's not an ideal scenario. An ideal scenario is one in which I'm instructed earlier, in which Mr. Sethi doesn't contract coronavirus and everything is submitted to you on time. But that's not the situation. And I believe, sir, that the documents presented for you in the witness statement would provide ample evidence to show why it was he didn't submit in time, and why that in relation to the application to set aside default judgment, that there are good grounds, there are good reasons to set aside this application, sir, and that he has a real defense. So unless I can assist you further, sir.
Yes, I think you should assist me in my coming question.
Okay,
Let me put it this way for you. Where your client, whatsoever, I mean, I would start to take on board whatever you have submitted about his health conditions.
Mm-hmm.
He was notified with the case. At some point, he decided to join this case to appoint a legal representative and to defend himself. That happened like by, I think, August or something. Is that August? Correct me if I'm wrong. So the lawyer were briefed by the defendant about what kind of available defense to him.
Mm-hmm.
The legal representative should have put all that before the court.
Yes.
So the defendant, despite his medical condition, managed to contact his lawyer
Yes.
to put all of the available defense documentation and whatsoever before his lawyer. The lawyer was in contact with the court up until the last hearing, what's supposed to take place on the 16th of November.
Yes.
If I'm not wrong. There is no, up until November 16th, there is no information about the defendant contacted with coronavirus issues, and to what extent that would have an impact on our case, on our ongoing case. We had the defense presented to us before. We had a skeleton argument that's been prepared by the law firms with certain defense elements it has, and against the law. Well, understand, I'm talking to you from the basis that the first when the application was lodged before this court in the ordinary way to tackle the default judgment. I don't know, I will need a very strong, let's say, submission and then evidence why during all of this process the legal representative could not have put up all of these defenses together at one time. Why they have not, once they extended the time last time to adjourn the hearing, they should have put up everything together. Why again we're putting all of this at last minute?
Yes, I think in terms of
this is a bit confusing for me, and yes. In the standard way this court is dealing with the cases, this is, I would call it, I would say, extraordinary situation. Usually we do not allow this to happen. We do not allow people to drag. Yes, if you be given a chance, I mean, your right is to defend your case. Your right is to defend your case in a proportionate time, proportionate way, proportionate cost, and proportionate effort.
Yes, sir.
You need to convince me why this is, how this is proportionate.
Yes. So I would say that in terms of timing, I can only say in terms of the instructions and what I understand. In terms of the matter, when they instructed Zayed Al-Shamsi, my understanding was he was a Part 1 JFC lawyer and not a Part 2. And my understanding was how I got on board was because they sought another counsel to act for them, but then I think at the very last minute they had to go abroad, and so that's how I sort of stepped in. But my understanding was in terms of the actual acknowledgement, so in terms of the acknowledgement of service, what I wanted to say in terms of this particular argument, if I may, I guess it will be, it's covered, or it will be covered in any event, is that my understanding is the way, if you look at how Zayed Al-Shamsi responds, it appears that they are acknowledging service, be it in the form that is not what the claimants want, be it not in the form that the judge is likely to receive. But if you look at the defense, which my learned friend also sends an attachment to, is in their response, they are in essence defense, and I believe in the RDC rules as well, you receive the defense as it is, regardless of the form. So I think in terms of dealing with the matter, there has been, from my understanding, there has been some movements, and that's why the cause for delay. But my greatest understanding of why the delay is in fact the medical, and I believe that in Mr. SETHI's witness statements, he has been very forthcoming in terms of what kind of documents in his medical that he's willing to present. And as I said, sir, I cannot speak on behalf of the witness, but only that the kind of impact it's had on him and his ability to instruct. And I do wish to say, sir, that it's difficult, and in relation to what my friend's argument will very much be, I don't think they can have it two ways. I don't think they can say, well, he never acknowledged our claim, and but at the same time he somehow managed to give instructions. I think the situation is more the scenario that he really, because of his illness, that was his priority number one, and that for whatever instructions he could give out, it was as and when he was able to. And I'm minded, sir, that actually in the defense that was submitted out, I believe it was in September 21st. That's prior to contracting coronavirus, sir. And again, the extent of the symptoms and that is not, here. But to say that, for example, when he contracted coronavirus in October the 5th, and then his wife contracting, so it's not for us to decide, for example, his recovery period.
I think you're missing the point. Let's talk about the September defense. Why the defense did not include everything he wants to say about the set-aside application? Why it does not include all evidence that he wants to submit?
Yeah. So
September defense was exactly between the coronavirus and the procedures he used to have in, let's say, July and August.
So I would say that he submitted it mainly in the bulk of the argument, the bulk of the main arguments in relation to ZILI, in relation to CVM, in relation to the rental, are all there. The second witness statement is in response to Mr. Serrano's witness statement, which is a lot more detailed. And I would say it's in line with also, as I said before, he may have had symptoms before going to the doctors and actually tested positive. And he's able to respond because he's recovered from COVID-19, sir. So if you ask me what's the difference before and afterwards, the difference before and afterwards, medically speaking, is he is recovered and he's able to handle it as of now in such detail. So I'm afraid, unless I can assist you further, sir.
Yeah, one of the criticisms to your application is that you're bringing a new submissions and a new evidence. Is that right? Is there any new evidence in regard of ground to set aside the application?
Yes,
sir. Things are not pleaded before?
Yes. So in relation to the crux of the arguments, it's already there. In relation to fleshing out the arguments in terms of detail, I would submit, sir, this calls for the very reason why this matter needs to be tried. Is because the claimant's argument is this is a very straightforward loan agreement. Unfortunately, it is not a straightforward loan agreement. It is one where there are embedded agreements prior to the formation of the loan agreement. And to assist you, sir, it wouldn't be fair for you to make a decision if this argument wasn't, I guess, expanded so that you could also understand where the claimant's argument, the Mr. Sethi's argument is. If you ask the basis of the defense and statement, it is in there. It is in the actual paperwork. But in terms of fleshing out, the second statement responds to, because you will find Mr. Serrano's argument saying that that his claims are frivolous, that there's no reason why he's submitting all of this. Well, there is a reason, sir, and that is why the reason is. I do apologize, sir. I do say that I've only been instructed in very late, time of the day. The only thing I can say is there is apologies for the delay, but yet for this particular case, that it would be duly, I believe, unfair for the courts, actually, for the courts and for the applicant to not have this matter, for this evidence to be heard, because you would not be able to make a fair decision without him explaining the full background to it. What is in the defense and what is in the initial skeleton argument and in the first witness statement does touch upon it, but it doesn't explain it in detail in the way that he's able to in response to Mr. Serrano's witness statement. Thank you, sir.
Thank you very much. I turn now to Ms. Hurst.
Judge, thank you. I think you probably have the arguments that I'm going to make, so I'll try and be brief because I'm conscious that we've got limited time. We do object to the witness statement going in. As you've already identified, we have to look at the relevant chronology. The point in time at which Mr. Sethi was under an obligation to acknowledge service is the 3rd of August. So whilst we're obviously very sympathetic that he has contracted coronavirus in October, that in my submission is irrelevant to the question of whether he had an excuse in August. One has to consider what the evidence is that is put forward, and the two broad points. One, he says that in August he was suffering from other medical issues. The criticism was taken in Mr. Serrano's evidence and in my skeleton argument that he hadn't in fact put forward any evidence of those medical conditions. And so he now belatedly tries to patch the gaps there. But also, Judge, as you've rightly identified, there are a whole raft.
Miss Helen, would you please go mute while Miss Person?
Sorry, I do apologize.
Judge, as you've identified, there's now a whole raft of new material in relation to what Mr. SETHI says are the relevant circumstances to this dispute. Now, obviously, we don't accept that they're relevant, but the fact is, his application was prepared in September. It was filed on the 21st of September. And in my submission, there is absolutely no reason why this background could not have been put forward on that date. He's been legally represented throughout. He was obviously in a position to instruct lawyers in August because they corresponded with the registry. And thereafter, those lawyers prepared his application to set aside the default judgment, which was served on the 21st of September. All of the material, and I do mean all of the material, in his second witness statement is background that relates to the background facts of this dispute and medical evidence in respect of the conditions that he was suffering from in June and July, save for his contracting of coronavirus. So in my submission, all of that material could have been put forward in his application, in his defence statement in September. Then Mr. Serrano's witness statement in response is filed on the 5th of October. Now, obviously, Mr. Serrano has to have an opportunity to respond to the facts that are put forward in Mr. SETHI's application. He does that on the 5th of October. And so, as my Lord knows, there is provision in the court rules that Mr. SETHI could have filed a witness statement in response. The deadline to do that would have been within 7 days, or by the 12th of October. So we are now almost 2 months past the date on which he should have filed a responsive witness statement. Now, we're sympathetic to the fact that Mr. SETHI's been suffering coronavirus, but in my submission, that has no impact on the relevant dates here. All of the points that are taken in the second witness statement could and should have been taken at the very latest by the 5th of October, but in my submission, in the application in September. It is obviously, Judge, procedurally unfair to my client that this witness statement is put forward 48 hours before the hearing. We have not had an opportunity to take instructions from Mr. Serrano as to the matters that are alleged, and manifestly he is not able to respond to them. The rules are there for a reason, the deadlines are there for a reason. Had Mr. SETHI's lawyers on the 12th of October said, "We're terribly sorry, but he's not in a position to file reply evidence, could we have a short extension?" Now, I'm sure that's something that could have been accommodated and provision could have been made for my client to file evidence in response. We're not there. We've instead been ambushed with a witness statement very much at the 11th hour with no opportunity to take instructions or respond. Ms. Tung prays in any procedural fairness for her client, but in my submission, the court has also to have regard to procedural fairness for my client, who's had no opportunity to respond to this material, which we say, in any event, could and should have been put forward at an earlier juncture. It's relevant also, Judge, that when this application was put forward, it was not filed with the registry. The registry then made directions to my learned friend and asked the witness statement in support of this application to explain why Mr. SETHI failed to file his evidence in time and why, if there is no new evidence, then why his current evidence is insufficient to deal with the matters raised. Now, Ms. Tung has not addressed you on that. There's no reason why he failed to file his evidence in time, because he wasn't suffering from coronavirus at that time. And there's no reason put forward why. If, as she says, this is simply flesh on the bones, why the bones are not sufficient for the purposes of this application. So we do object, my Lord. I don't want to take up valuable time for the hearing itself, so unless I can assist you further, those are my submissions.
What do you say to the point that she's saying it's just an elaboration on the first witness statement, and even in the, let's say, the defense and the skeleton argument that was submitted on September?
Well, firstly, Judge, that if that was right, then there's no reason why this elaboration is needed, and she could simply rely on the first evidence. But more importantly, it raises some 8 pages worth of detailed factual points, evidence about meetings, about background, about discussions that were had with my client, various transactions, various different issues, none of which we can immediately see are relevant, but of course which we would want to investigate and take instructions on. It appears, I'm afraid to say, that what happened was the claimants received, the applicant received our skeleton argument for the hearing which was adjourned, realised that there were gaping holes in their case, and have belatedly gone away to try and patch up those holes. And we say that that's not procedurally fair.
I see. I have one question before we go on with this submissions. First, I'm asking you, is it in your defense or is it way in your submission that this loan agreement has an entire contract clause? So then it would be much easier for us to assess whether.
Judge, I will have to take a minute and check the written agreement to answer your lordship's question. Judge, the loan agreement is at pages K2 and K3 of the bundle. I don't believe there is an entire agreement clause. There is a clause that states the loan agreement is governed by GIFC courts.
You say the exhibit behind tab K?
Yes, it's tab K and it's at page K2.
K2, and
Sorry,
what paragraph you're in?
M3, M4 has a better version of the loan agreement, if it assists.
I'm very grateful.
Okay, Ms. Hurst, what's the paragraph? What clause you're referring me to?
Judge, I'm simply noting that
Yes.
clause 3 is the clause which says that it's governed by GIFC courts, GIFC law,
Yeah.
but there is no entire agreement clause that I can see.
Mm-hmm. Well, in this scenario, then what I'm going to do, Ms. Hurst, I would, in my view, I will deal with both applications at one time. I will ask Ms. Tung to go on with her submission, and Ms. Tung, I would urge you that whenever you're trying to emphasize in any ground for set aside the application, try to make a link on the basis that at least the ground you're referring to has a basis in the first defense and then in the application to set aside. She's with us, Ms. Tung.
Thank you, sir.
Yeah. Am I addressing you in the right way?
Yes, yes.
Sure. Helen Tong, is that right?
Yes, that's correct, sir. Thank you very much. So the main documents I want to refer you to is the defense statement, which you will find in C1 to C7, the application filed by the defense, which is B2 to B5, Mr. AJ's first witness statement, E3 to E4, the second witness statement, which is S1, including the medical, is S2, and of course the loan agreement, which my learned friend has just mentioned, but actually I prefer the claimant's version because it's much clearer, and it's M3 to M4. So without further ado, I'm going to go straight into the application to set aside default judgment. As you will know, sir, the provisions, if I may just quickly, under Article 14.1 is the court must set aside the judgment if under Part 13, if the judgment was wrongly entered because, in the case of judgment, in a default of acknowledgement of service. And it goes further, that number 42 is in any other case, the court may, on other conditions as see fit, set aside ordinary judgment entered under Part 13, if 1, the defendant has a real prospect of successfully defending the claim. 2, it appears to the court that there is some other good reason why A, the judgment should be set aside or varied, or B, the defendant should be allowed to defend the claim. So with that, I will go straight into it. So what I want to refer you to is obviously referring to the skeleton argument as well. Mr. Serrano's witness statement, I'm just drawing a parallel. In paragraph 19, it's M7 of the tab, Mr. Serrano would quote actually Mr. SETHI saying, "We have agreed the dates and time schedule specified by the DIFC and our law firm shall be submitting per procedures." We also see in the affidavit of Mr. Nicholas Bragaze in J1 to J7 that they've filed
Hello? We do not hear you, Ms. Tong.
Sorry, I do apologize. I don't know if something got cut off. So apologies for the technical.
So what is the reference? Is that M7?
Sorry, yes, M7 for Mr. Serrano's witness statement.
No, M7 with me is something else. It's a letter. It's an email.
Oh, sorry. Okay, let me have a quick look.
From Mr. AJAY to his law firm.
Okay, sorry, so let me just. Okay, I see it's been rearranged. Okay. Okay, so allow me to get back to that. But in essence, what I'm trying to say is you will notice that Mr. SETHI has responded in the correspondence with the claimant's solicitors. Now, if the certificate of service, as Mr. Bragazi would say, is July the 6th, 2020, then they propose that the date for acknowledgement service would be July the 20th. And the form and filing defense is 45 days from that, which would make it Thursday the 20th of August. Now, so if you are not with me in terms of acknowledgement of service, and we say actually in terms of timing, that there are dates, for example, which we would say is filed between the date they say they serve and the defense. So if I refer you to the first witness statement of Mr. SETHI, and this is in paragraph 4, I have to apologize.
Is that behind tab E?
Allow me to go in.
Are you having difficulties, opening the case line?
Yes, Yes, it is tab E, sir. Yes, it's tab E. That you will see that because of business and business loss and coronavirus issues. Sorry, this is paragraph 6. In paragraph 6, as a matter of fact, the failure was not because of his willful neglect or laches, but due to my facts beyond my control, as explained above. And this is specifically in relation to his medical. And so, as I've already mentioned, I don't want to labor the point about his medical situation, but that is his reason for the delay. And that the email format was actually, there was a response from the court on August the 10th, which I believe was to ask them to submit on the e-registry. So you will see also in the email, which is dated the August the 9th in 2020, from Mr. Saeed Al-Shamsi to the claimant solicitors, kindly find attached reply memo on the above mentioned case number. And that is also the document that my learned friend included. The memo, I believe, is Y1. You will see that there are attempts to submit the acknowledgement, be it that it's not in the correct form. And there's a difference, sir, between filing acknowledgement of service late and never filing at all. So I would acknowledge, sir, that they have made attempts to file. My understanding that, in fact, on the August the 10th, when they were filing, there were technical delays, but you will see in the defense witness statement of Mr. Sethi that they did submit on at 6:15 p.m. That's the understanding. If I combine this with the medical, which I mentioned, sir, earlier, it does explain the reasons, and I don't wish to repeat myself, but I just want to emphasize that because of the medical, that was the main reason. So for the delays. So now I want to move on to the loan agreement, which I believe, sir, is in essence the crux of it. And I want to focus on the formation of the loan agreement. So you will see that there are documents pertaining to 3 main businesses. One is in relation to ZELI, one is in relation to the ZVM, and one is in relation to the villas. So if I start with ZILI, maybe that will assist you. So ZILI, if I may explain, sir, is a high brand menswear headquartered, I believe, in France. And you will see in the correspondence that, in fact, if we go in terms of chronology, back in December 18th, 2017, that there was an introduction, well, there's an email from Mr. Ziad Barakat to Laurent Chemel, ceasing Mr. Sethi and a Frank Lamisia, that they met actually, and from there on, there are other emails that show that there were discussions about business, about making it a huge success. And in that email, Mr. Sethi was CC'd in, and that there was actually a financial plan as well. And you will also see responses from this, Alain Chemel, the CEO of ZELI, welcoming them to their joint visit, and an email from Mr. Sethi himself expressing the desire to do business together, and the importance and significance of that is if you were to then go to the defense statement, you will see Mr. Sethi listing out the losses. Okay, so it's to put it in context. I want to take it step by step so you can understand the context. So the conversations with ZILI was back at least starting from 2017. So at least 3 years conversation. And the way I want to position this, and I'll mention CBN and the loan agreement, and you will see how the loan agreement comes in terms of relevance.
Mm-hmm. That's next, what I want to hear, yes.
Next, we look at CVM. So in CVM, you will see in the tabs the documentation regarding a sale and purchase agreement. And here it is a sale purchase agreement between Mr. Ziad Barakat and Mr. AJAY. You will see that it's in relation to a shareholding within the Stark enterprise of CVM. And it's a share owned by Anamika, where Mr. AJAY actually increases his share by 4% by paying about $500,000, $500,000 and purchasing the share. Behind the CVM documentation, you will find that there's two internal memos which shows the profits of CVM. I should mention that this is a business that Mr. SETHI introduced to my client to say, look at the profits, look at the businesses that you're able to make. The third thing is in relation to the tenancy agreement, which I would say, sir, is very important. The tenancy agreement dated December the 15th has a contract value of AED 8,400,000. Now you will see in the contract, the initial contract phase is for 3 years, from February the 1st, 2016 to February the 28th, 2019, of 3 years. And it was originally signed, and so to just explain the relationship between Mr. SETHI and my client, Mr. SETHI, is that of a landlord and tenant, where my client was the landlord and Mr. SETHI was the tenant. He signed that contract specifically for an annual rental of AED 2,800,000. And that you will find later on from March the 1st, 2019 to July the 31st, 2020, changed to half the rental amount, which is 1,600,000. Now, the question that begs asking is, why did the rental go from 2,800,000 per annum down to 1,600,000, i.e. half the rental? And now I can talk about the formation of the loan agreement, sir. With the ZILI agreement, with the promise of doing business, and the context is my client has managed to obtain the exclusive franchise from Mr. ZILI, the CEO based in France, to set up an office in Abu Dhabi, which Mr. SETHI was very excited about and in which he promised to pay 2 million. You have the CVM, in which it was Mr. SETHI engaging my client, say, look, we are supplying sand to ADNOC, we are generating, and I can promise you about 600 to 800 million times profit. And guess what? If you help me by halving your rent, we can do business. You do all this for me, I do all this for you. You rub my back, I rub your back. That was the only reason why my client decreased the rental amount, and he asked for, when I say he, I meant Mr. SETHI, the claimant, asked for 6 months free rent. Now, you will also see damages to the property, etc. I'm not going to labor on that because there is a separate claim on that which is currently being dealt with separately. So I'm purely focusing on the rental and the 6 months that was unpaid for. Come the loan agreement. In the witness statement of Mr. SETHI, first witness statement, and also in the defense, and also in the application, you will find that Mr. SETHI knew Mr. SETHI's financial situation. He was in distress, clearly because as a tenant, he was paying half the amount. And not only that, they were talking business consistently. They had coffees, they had travel trips, and so forth. So in this loan agreement, which my client in the second witness statement would say, it is because Mr. SETHI knew Mr. SETHI's dire financial situation that this loan came about. Otherwise, he would not have given him that loan. Now, it needs to be mentioned that the check of 5,000 was also something that Mr. SETHI asked my client, which my client reluctantly signed because he acted on the basis, on the representation. We have this ZILI business going on, which you would get about 1 million. You have this ZVN business, which we're working on, which you will get 600 to 800 million profits on it. And so why not? Why not sign this loan agreement, which I will lend you 1.2 million or so? The excess interest rate is something of interest, sir. And this is where I will touch upon the authority in the unfair contract business terms. But allow me to just explain that in his witness statement, the only reason the formation and the way this loan agreement came about is because of the understanding on the deliverables, i.e. the representations by Mr. SETHI to Mr. SETHI, because you are joining me in my business and we're going to do X, Y, and Z, I'm going to give you this loan agreement. You are going to pay me these large sums of interest Because, by the way, you're going to profit anyway, up to 800% on the profits. So why not? So this was how Mr. Sethi understood and hence signed the agreement on that basis. He would otherwise would not have signed in any other circumstance. So I now want to draw upon the authority, which is the unfair, in essence, the unfair contract terms. Just give me a moment. I need to find it.
Excuse me, Ms. Tang, is it in your submission that
Yes.
your client never needed that loan amount and he just signed it?
No.
For the sake of giving Mrs. Sethi and certain for profit as encouragement, or I don't know.
No. It's not that case. It is actually genuinely because Mr. Sethi was in financial difficulties, and the financial difficulties in which Mr. Sethi also knew of, because he was paying half the rent. You understand? So for example, in terms of the property,
is it an implied term? The payment of this loan agreement would be done by different certain way, the rent, the other businesses?
Well, it was on the understanding that he would be joining the business in the Sethi. Okay, let's assume for the moment, Sethi, the business in Zili succeeds. The business in CVN succeeds.
Right.
On that basis, that is how the repayment terms, the percentage on the interest rate on the loan came about. Because if you imagine for a moment, if it was a successful business, of course Mr. Sethi can pay. This is the thinking behind this loan agreement. But the difficulty, which I'm about to bring you to, is Mr. Sethi never delivered on his word. In fact, he jeopardized the business in Zili. You will see in his second witness statement, and also in his claim form, quite clearly, the business never went through because of his behavior, his erratic behavior in unable to deliver. And because, you see, Mr. Sethi, in essence, prior to Mr. Sethi coming into the picture, had the exclusive franchise. You will see it in the Zili documents. Mr. Sethi comes into the picture, says, hey, I want a slice of the pie. I want to contribute about $2 million. I can bring it in line with my other business, Newbie. But instead, he loses the whole deal. He loses the whole deal, and Mr. Sethi is left with nothing. Now, this is all prior to, of course, the signing of the loan agreement, maybe if I could put it this way, is on the basis of optimism, of the fact that we have two major businesses we are going to work on together, i.e. Mr. Sethi, Mr. Sethi. They're going to work on Zili together. It was a very ambitious project, sir. It was a project to basically develop, design.
Mr. You need to submit it either way. This is either a motivating factor why the loan agreement being signed, or it's an implied condition. One way of paying the loan is doing another business.
Yes.
And how that is going to come, and that's a higher burden for you to get into it and to prove, not just to say, oh, we have another business, and how that form an implied term or implied repayment.
So it was oral discussion, sir, between.
It's not yet in your defense. The way I'm saying that is an implied term.
Yes, sir. It's in.
So, yes.
So if I may, sir, I just need to give me a moment. On the contract law. Sorry, so if I can draw your attention to the implied terms in contracts and unfair law. I'm just taking it out of my bundle. I believe it's under T.
What's the reference?
I believe it's under T.
Yes.
Yeah. So if you go to part 3 on unfair terms, firstly, under Article 35, insofar it relates to liability in contract, the party applies to any contract governed by the law of JFC. And in this case, sir, I would say that the agreements which there is evidence, obviously not submitted here, but in terms of more detailed evidence, is available in that regard. The scope, I would submit, sir, the liability, Article 38, arising in the contract. And what I want to point out to you, sir, is Article 40, the reasonable test. And I want to go through a few of the clauses Article 41, in relation to a contract term, the requirement of reasonableness for the purpose of this law is that the term shall be fair, reasonable, and one to include it of having regard to the circumstances which were or ought reasonably to have been known or in contemplation of the parties when the contract was made. First, clause 43, in relation to a notice, the requirement of reasonable under this law is that it should be fair and reasonable to allow reliance on it, having regard to all the circumstances obtaining when the liability arose or would have arisen. And then finally, and most importantly, is 40A and B, is where reference to the contract, A, the resources which he would expect to be available to him for the purposes of meeting the liability should it arise, and B, how far it was open to him to cover himself, okay, by insurance. So focus on 4A, okay. So imagine for a moment you have the discussions with Zilli, you have the discussions with ZVN. My client, because Mr. Sathia says, we're going to do this business anyway, why don't you half the rent? Mr. Sathia believes so and does so, offers, and also he's asked for 6 months rent, he offers the 6 months free rent.
Wait. You know what you're saying now?
Yes.
You're saying, why we don't make the rent half? Because we're getting into another business.
Yes, it was all, it was all in parallel.
When you refer to the business, you're not referring to the loan agreement, isn't it? Because
it's information of the loan agreement. So the loan agreement comes in with that kind of interest rate, so 26%, 38%. If I were to ask you, would any reasonable businessman sign up to this? The question has to be no. You would negotiate at least. No, sir. If you're a reasonable businessman, you go to the bank, would you take out a loan on such a high interest rate? The only reason that my client signed up to this loan agreement is on the basis of the representations made by Mr. Sethi, be it under NS International. Because of these businesses, we will do these businesses, I will give you this loan, you will sign this loan agreement, you will pay me this interest rate. And I would say, sir, my client signed this in total reluctance, but induced by the fact that there are these businesses in the pipeline, sir. Because I would propose, sir, no reasonable person, even under this reasonable test, sir, how would you envisage Mr. Sethi paying for this kind of a loan with this kind of an interest if he didn't know there was money coming in from some other business? This is the argument we're trying to present, sir. This is how one has to consider, is it reasonable? And so I will now also want to draw your attention to the further...
A reasonable businessman don't need to take a small loan with a very higher interest and give half of his rent away in favor to get into another business. He could do a reasonable arrangement in getting into any business he wished to do.
So I appreciate where you're coming from. I certainly understand that. And that is why we're saying this is a matter that needs to be tried. Because there is evidence. There is WhatsApp messages, there are emails, there are correspondences which will show you in terms of timetable and scale how the conversations come about. That is why I am at pains to emphasize the Zilli discussion occurred back in 2017 and the CVM came in 2000, a bit after, and then how the tenancy, right after the tenancy agreement, it does not make any sense. So why a landlord would half their rent in millions? Right? One has to ask the question, why are you halving the rent for 1 million? Right? And the reason is because of the leading up to this loan agreement. And so if I may turn your attention, actually...
before you go to that, can we, I mean, before we go to this an implied term and there is an hypothetical repayment of the loan and the link between this loan and another business, is it in your argument, is it in your defense that there were actual money being paid toward the repayment of this loan, which was not mentioned by the claimant? Because if you start with that, that would be should be primary ground to set aside against the duty of full and frank disclosure by the claimant in the first application, and as I said, acknowledgement of payment. That first of all would put you in better position if that's in your first defense. So even you will avoid getting, and then if you failed in that, if you think that is not sufficient, then you can jump into another point and say, well, the repayment has taken another method. 1, 2, 3.
Yes, thank you, sir. Yes, of course, there has been repayments made, and in sums, and it's highlighted in the defence and also in his witness statement, and it's also in the bundle as well. There's no doubt, sir, that
a repayment never acknowledged by the claimant. You mean? Until they get the default judgment.
Sorry, sir. Come again.
I said, are you taking me to a payment or repayment of the loan and never mentioned by the claimant in its claim form? It's never been acknowledged at all. It's only come to the court the first time in the set-aside application.
So I'm unable. I'll need to take further instructions. I'm unable at this point to sort of explain. My only understanding is that yes, there has been repayment made, and that it is a loan, and yet the context of how this loan came about, I submit, sir, is more complicated and needs to go to trial. So if I may just finish, if I can, in terms of the schedule, I also put it's still under T20 clause 8 in the schedule, is a thing is deemed to be done in good faith within the meaning of this law when it is done honestly, when it's done not negligently or not, and so finally, sir, and also I already mentioned the reasonable test, but there's the Schedule 2, which further details, is saying the matter with regards in the particular purpose of reasonable as follows: the strength of the bargaining positions of the parties. So if you look at the loan agreement, sir, it is certainly one-sided. Taking into account alternative means in which the customer's requirements could have been met. B, whether the customer received an inducement to agree to the term, which is what we are arguing, sir, that there was that there, and in accepting it, an opportunity in entering a similar contract others, and whether the customer knew or ought to have known of the existing extent of the term. So my client's defense or application to set aside is quite simply, he signed this agreement with the understanding that there are other agreements as part of this, and he would not have signed this agreement were it not for these other businesses which Mr. SETHI, my client would argue, has failed to deliver on. So, and I should also mention, I would like to wrap up, sir. I want to touch upon some of the case law that my learned colleagues have submitted. There are 4 case laws that they have submitted. In relation to ESAM, it's in relation to filing acknowledge of defence. My argument, sir, as I presented before, it's not that my client has failed to acknowledge service, it's that they haven't filed it in the form that is desired by the claimants, and be it that there is delay does not mean they have not at all. In relation to the second case, EBI, SA France, I would acknowledge again that my client did file in response. Thirdly is in relation to investment group, and that one is in relation to an offer and set off, and I thank my learned friend for that. So with the court's permission, I would touch on that point as well. And then fourthly is the industrial group, that there has to be a close relationship. Paragraph 5, a very close relationship between the A's claim against B and B's claim against A. And this is precisely the point that I want to present, sir, is the loan agreement and the defense submitted by my client is not frivolous, it's not different, it is not separate, they are interlinked together. If you look purely on the evidence of the rental agreement, something has to be explained there. And I'm giving you the explanation, sir, which you can understand the context behind. And in relation to all the email correspondences leading up to, it is important, sir. Why? Because otherwise, the case would be presented exactly how the claimant would like you to see it, which is, it is purely a loan agreement. But the backstory behind the formation of this loan agreement is equally, if not more important, in order for the judge to make a fair decision. So that, with your permission, sir, there are 4 things that I would like the judge to consider, is to firstly, to bring Mr. Nimal Sathia into the claim, because in all honesty, this loan agreement and the related agreements is actually pertaining to the engagements that he had, and you will see in the silly correspondence that Mr. Mr. SETHI, whilst in the emails or whilst be it that he's a director or behind MS International, he plays a very active role in the actual engagements with the business in Zili and also in CVM. That secondly, in relation to SETHI, thank you for my learned friend for bringing this up, is for permission to submit it if for this matter to be heard in for matter to be heard in trial, and for a counterclaim to be submitted with the court's permission. Thirdly, it's costing the case, and obviously the other witness is a Mr. Barakat, who has been a party to all the business discussions. So with that, sir, unless I can assist you further, those are my submissions as to why the default judgment should be set aside, that my client has real prospects of success in hearing the claim, and that there are other good reasons which I've elaborated on why the matter needs to be heard in court. Thank you, sir.
Yeah, I have one simple question for you, which is that, is it in your submission that it's either as a way of repayment of the loan or why this loan being signed is to sign another business? So if the other business, the other businesses, because there were 3 businesses plus rent, were successful, your client won't be asked to repay this loan, or he would have made more money, then he would be able to pay this loan in an easier way. What direction you're taking?
So I would need to take instructions on that. I mean, from what I understand is...
Well, you've been making a link between this business and the loan, and now you want to take instruction.
Well, sir, I mean, my understanding of how this loan came about is on the basis, basis of this agreement. So in theory, and again, I'll take instructions. If, for instance, the business is not delivered and I take a loan on this basis and with this kind of an interest, then it could be argued, sir. But the fact is my client has made some repayments, and that's why I would say I need to take further instructions, sir.
Okay, I tell you what, while you're taking further instruction, I will turn to Ms. Hurst to hear from her defense against your application to set aside. Ms. Hurst?
Thank you, Judge. My skeleton argument is at tab N of the bundle. It might be useful to have that in front of you. I'll try and be brief. I know we're running short on time. It seems to me that there are 2 points made by Ms. Tung. The first is that it's suggested that an acknowledgement of service was filed, and that somehow that gives her grounds to have the judgment set aside. And then there's obviously the point made about real prospects of successfully defending. So I'll deal with both of those. I won't repeat, Judge, what's set out at paragraph 4 of my skeleton, which sets out the background. But I do emphasise, in contrast to my learner friend submissions, this is a simple claim. It's a claim on a loan that was signed. You've seen the loan agreement, Judge. I can take you back to it if you'd like, but it clearly has Mr. SETHI's signature. He's agreed to those terms, and as I'll come on to show you, he's in fact accepted and abided by those terms. It's notable and remarkable, and we say conclusive, that nowhere in my learned friend's submissions did she suggest to you that there is any argument whatsoever that this loan agreement doesn't fall to be repaid. All that's been said, leaving aside an argument on interest, which I'll deal with, all that's said to you is in fact that money might have come from somewhere else to pay the loan and it's not coming. Well, I intend to show you that that's not good enough to amount to a defence, but I ask, Judge, that you have firmly in mind the parameters of this dispute, that it is a commercial agreement, a loan signed between 2 parties, businessmen acting at arm's length. The terms are what they are, they haven't been paid, and we say that we're entitled to repayment. As for the point on acknowledgement of service, I think it is important that we look at the documents. As this is set out, my Lord, paragraphs 5 to 12, 5 to 13, the relevant chronology of events. So the claim form was served on the 6th of July. Mr. SETHI, in fact, tried to resist service. He wouldn't accept delivery by the courier, but it was subsequently served on his lawyers, and the certificate of service was filed. There is then the email that you've already been taken to by Mr. SETHI saying he wrote to Mr. Braganza, that's Mr. Braganza of Clyde & Co, my instructing solicitors, saying that he would, we've agreed the dates and time schedule and our law firm shall be submitting as per procedures. So he specifically acknowledged and understood that he would have to acknowledge service and abide by the timetable and the rules of the court, and of course he's instructed lawyers. He has legal representatives who are no doubt aware of the rules and the timeframes, and I've set those timeframes out at paragraph 9. The deadline for filing an acknowledgement of service relevantly is the 3rd of August. On the 9th of August, Mr. SETHI's representatives tried to submit the reply document. Now, I pause there to emphasise the obvious point that that is already out of time, and so there was no acknowledgement of service filed by the deadline, which is, of course, the relevant factor for obtaining the default judgment. But in any event, that reply memorandum, it's worth possibly looking at that. It's at tab Y of the bundle. It's entitled, I don't know if you have that in front of you, Judge, it's titled Sub-Reply Memo.
Behind tab?
Tab Y, letter Y, right, it's right at the bottom of the bundle.
Yes, I do have it, yes.
So it's entitled Sub-Reply Memo. There's a couple of pages, and then scrolling down to the bottom, it's signed, it's respectfully submitted and signed by Mr. Al-Shamsi, the defendant's representative. It's obviously not, Judge, called a defence or acknowledgement of service. It's not in the correct form, and there is no statement of truth in breach of the rules. So we say that wasn't an acknowledgement of service and it wasn't a defence, but also, and more importantly, neither was it filed with the registry. It was emailed, and we see at page K9 of the bundle, this is the exhibit to Mr. Braganza's witness statement in support of the application for default judgment. So, page K9, I hope you have that. This is at the bottom of the page. The bottom of the page, there's an email saying, kindly find attached reply memo, not acknowledgement of service, not defence. That's sent to the registry. And then the response from the registry on the 10th of August says, dear sirs, please ensure that you file all submissions online via the e-registry portal. So the registry clearly think that this is a submission document rather than an acknowledgement of service or a defence. But in any event, this is a clear direction from the Deputy Registrar saying that this document needs to be filed. It has not been filed and it needs to be filed. And Judge, that was never done. It has never been filed on the e-registry. And I emphasise that because, of course, Mr. SETHI is legally represented. There's absolutely no explanation has ever been given in his defence statement, in his witness statement, or even this latest witness statement, as to why he failed to comply with the registry's directions. The clear instructions here that the document needed to be filed, and it wasn't done. And the reason I emphasise that, my lord, is that obviously under Rule 13.4 of the Rules of Court, which is the relevant rule that needs to be ticked prior to getting the default judgment, it says very clearly that a default judgment can be entered if the defendant has not filed an acknowledgement of service or a defence. And we say that can only mean filed with the registry in accordance with its proper procedure. That wasn't done, and the fact that it was not done cannot be down to any ignorance because he was specifically told exactly what to do, and it wasn't done. It has never been done. Neither, I emphasise, neither has his defence statement been filed on the portal. That still hasn't been done. So there is a clear and ongoing failure to comply with the correct procedural rules, but that in any event, the precondition for entering the default judgment was satisfied. There was no filing of an acknowledgement of service by the relevant deadline, and accordingly my clients were entitled to apply for the default judgment. One final point on that, Mona, just to be clear, it has been said against me in the skeleton argument. Doesn't appear to have been pursued in submissions, but it was suggested that somehow those instructing me had deliberately suppressed this acknowledgement of service and not drawn the court's attention to it when applying for default judgment. That's obviously a serious allegation, and in any event, it's completely incorrect. The exhibit that I've just taken you to, K9, is the exhibit to Mr. Braganza's affidavit, which is at tab J, which explains very clearly at paragraph 25 on page J4, explains exactly what I've just taken your lordship through, that this document was emailed, it wasn't filed, the registry told Mr. SETHI's lawyers to file it, and that wasn't done. And obviously the emails are exhibited. So we do reject any suggestion that the default judgment was entered without drawing the court's attention to all relevant matters. So we say on that basis that the judgment, there is no grounds for setting aside the judgment under Rule 14.1. The relevant conditions are satisfied. There was no acknowledgement of service or defence filed in time. And accordingly, this is a regular judgment. Excuse me. And therefore, if your lordship is to set aside a regular judgment, then the only grounds for doing so is under REC 14.2, which my learned friend has already taken you to, but the court must be satisfied that the defendant has a real prospect of successfully defending the claim, or that there's some other good reason. And I've set out at paragraph 18 and 19 of my skeleton argument what that test means. The court will be very familiar with these authorities, but just for reference, a real prospect of success means that the defendant has to show a real rather than fanciful chance of success. And what that means is that the court does not have to take every assertion that the defendant puts forward at face value, but is entitled to stand back and assess whether, scrutinise those arguments, scrutinise the evidence, and ask whether in reality that has any prospect of meeting the claim put forward. I've also relied at paragraph 19 on the case of AJAY and Lal Mahal, and it's possibly worth just looking at that case very briefly. That is at tab, one second. It's at tab P of the bundle. And this is a case where 4 defences were put forward, and Justice Roger Giles allowed a defence to be advanced on the basis of lack of jurisdiction, but dismissed the other 3 grounds as having no realistic prospect of success. And I think it's possibly worth just looking quickly at them. One sees at paragraph 20, for example, a defence of misjoinder of parties, and he says there's nothing in this defence. Paragraph 23, this is in the context of an argument for abuse of process. Just the final sentence of that, any wider disputes linking the claimant's claims in these proceedings with the Nigerian proceedings was not explained. And I emphasise that because, as I will come on to explain, whether there are other disputes or whether there are other complaints put forward by the defendant, it is incumbent on him to explain how that has any impact on the legal claim that's advanced in these proceedings. If that hasn't been explained adequately in evidence, then that's not a good defence. And similar remarks at paragraph 30. The final sentence in regards to this defence, which was alleged to do with a breach of facility letter, it was not explained how the asserted waiver affected the claims against the guarantors, specifically the claims against Lal Mahal. So I just emphasise, Judge, that the burden on the defendant is not just to put forward a whole raft of material which muddies the background and makes various assertions, but also to explain how that relates to the legal claim that's advanced and why it is relevant to this claim. One final authority that I think it's worth looking at briefly is in tab X. And which was another application to set aside default judgment that was refused. The defence that was put forward was based entirely upon material put forward in an expert report. And what's said at paragraph 5, I think, is instructive. The claims which were made in the expert's report, Justice Field found, are properly characterised as a counterclaim. They do not, in my judgment, amount to a defence. For there to be a defence by way of a cross-claim, the cross-claim must amount to what the law calls a set-off, and there can only be a set-off where there is a very close relationship between A's claim against B and B's claim against A. In my judgment, there is no sufficient relationship between the claim made by the claimants for payments, which is very similar to the claim made here, and other claims which had been identified in the expert's report. So I ask, Judge, that you bear those authorities in mind when I come to address my learned friend's submissions on the defences that have been advanced. I'm going to focus on the defences that have been put forward in the defence statement. I do emphasise, Judge, that much of what my learned friend has said to you this morning is entirely new to us. It hasn't been put forward in the defence statement. It hasn't been prefigured in Mr. SETHI's witness statement, and it's barely been touched on in the second witness statement, although I confess I've had very little time to look at that document and deal with it. But I will address those points as far as I can and show you that actually they still don't have any basis. But I do emphasise the procedural unfairness of legal arguments being sprung upon us during the hearing to deal with. But I will assist you as best I can. So the way I see matters, I think there are 5 now legal defences advanced. There's a complaint made about a cheque for 50 million dirham, which it said has not been accounted for. There's a complaint made about payments that have been made, and it said that those have not been accounted for. There's a complaint made about interest, and then there's this argument for set-off of all of these possible various claims in relation to the business. And I take those in turn at paragraph 26 of my skeleton, so it's possibly worth returning to that at tab N. Excuse me, Judge. The cheque I can take very quickly. It says at clause 5 of the loan agreement, and I can take you back to that if you'd like to look at it, that the cheque is going to be received by way of a security. And if full repayment isn't made within 60 days, the cheque can be cashed in, and that will reduce down the amount of the liability. So it was effectively a security document. It's explained in the particulars of claim that actually what happened was that when Mr. SETHI failed to pay, my clients did try and cash that security. The cheque was dishonoured, so it was returned unpaid. No sums were drawn on the cheque because it bounced. And there were proceedings in the onshore courts of Dubai in relation to that. But the fact remains that it was dishonoured, and so no deduction falls to be made for it because there has been no payment in the sum of 5 million or at all. It's been said that repayments of the loan have been made and that those haven't been accounted for. That is not correct. If one looks at the particulars of claim, which is tab H, I can take this point very briefly. One sees at paragraph 14.2, which begins at page.
What is the particular of a claim?
It's tab H, Judge, and I'm looking at page H3.
Yes. H3, yes.
So under paragraph 14, particulars of breach, there's a subheading, and 14.2, right at the bottom of the page, it's pleaded, in breach of its obligation, the claimant failed to pay the interest accrued. On 3rd of September 2019 and 8th of September 2019, the defendant has made partial payments towards this interest in the amount of approximately $50,000 US. That's over on the top of page H4. However, the defendant has failed to pay the remaining amount. So it is specifically acknowledged in the claim that there has been partial payments, and they have been accounted for, so they have been deducted from the amount claimed at the bottom of the particulars of claim. And in fact, if one looks at the documents submitted with the defence statement at tab C, the documents that are relied on are at page C. I'll have to use the English translations, I'm afraid. So page C19. Scrolling down to that. These are the documents put forward by Mr. SETHI to say that payments have not been accounted for. It's a very bad copy, I'm afraid, at C19. But you can see a table in the middle of the page. And it says purpose of remittance. This is a payment remittance that he relies on, purpose of remittance. And the explanation that's given there, it says towards interest payment. And there's another example of that on page C21, which is perhaps a bit clearer if one scrolls down to page C21. Again, these are the remittances relied on by Mr. SETHI. It says remittance information, interest payment. And as I've just explained, paragraph 14.2, those payments were indeed made in respect of interest. They have been deducted from the amount that's being claimed, and so they have fairly been taken into account. There is no claiming for amounts that have already been repaid. That's already taken into account. And so we say that there's no real prospect of a defence on these grounds because those payments have already been factored into the amount that's being claimed. I also say that that is an answer to the argument that's put forward that the interest rate is too high or is too oppressive. First and foremost, Mr. SETHI has obviously acknowledged that that interest is payable because he has been making repayments towards them, so he accepts that term applies, and he's been performing the contract in accordance to that term. It was said in the defence statement that there is an argument, a defence against the interest on the basis of usury or Sharia law. In my submission, I'll set out in my skeleton argument of paragraph C, that defence has no prospect of success because it's this loan agreement is governed by DIFC law. It seems my learned friend accepts that because she has taken you to the DIFC unfair terms law. So we say no real prospect of defending on the basis of principles of Sharia law. As to DIFC law, I emphasise this is a completely new point that was taken for the first time in submissions, but in any event it is absolutely baseless. If one looks at that law, it's at tab T, the implied terms and unfair terms law. If one turns back to article 38,
T38.
It's article 38, it's T17. In fact, it might be worth beginning on page T16. Now, it was suggested to you in submissions that the court could assess this interest clause on the basis of a reasonableness test, and that the court was entitled to conclude that the interest charge was not reasonable. That, I'm afraid, is a misreading of this statute and how it applies. The unfair terms clause does not give the court jurisdiction to assess every single term of an agreement on the basis of reasonableness. It's in fact a very tight, only certain types of clause are subjected to that test. So one sees at Article 38, which is headed liability arising in contracts, if the parties, and I'm paraphrasing what's in front of you, but if the parties deal on standard terms of business, if there is a term which purports to allow one of the parties to restrict their liability, that's term A, or to render contractual performance substantially different from that which is expected, that's term B, then those terms are they are deemed unfair and therefore struck out of contract unless it satisfies the requirement of reasonableness. And then the reasonableness test that you were taken to is Article 40. But my lord, that does not apply to the interest clause. The interest clause is not a term which purports to restrict liability. It's not a term that claims to entitle my clients to render different contractual performance. It's simply a clause charging interest. So we say there is no application whatsoever of the reasonableness test to the interest clause. This law simply does not apply in the way that my learned friend has tried to argue. So we say that there is no real prospect of defending the claim for interest on the basis of its alleged unreasonableness. That's simply wrong in law. The remaining defences then, Judge, are the various allegations which are put forward in the defence statement and lately fleshed out, to use my learned friend's word, in the second witness statement. These points, we say, are entirely incoherent and substantially unevidenced, and in fact very difficult to follow. The first time that there has really been a narrative or an explanation has again been this morning in submissions. But we say, even taking my learned friend's arguments at their highest, they are irrelevant and do not amount to a defence in law. It's worth taking a step back, I think, and asking what the legal relevance of everything that my learned friend has said to you, what it actually amounts to. It's not alleged anywhere, nor has it been said by my learned friend, that this loan agreement is not valid and enforceable, that it's not binding between the parties, or that the sums that are due under it are not payable. What seems to be said is that there were various background agreements in relation to ZILI and other projects, a potential partnership agreement, discussions between two businessmen as to a way that they might go into business, negotiations around a rent for the villa, none of which we say has any bearing whatsoever on the liability that arises under this loan. At best, it was said that out of optimism, I think that was my learned friend's phrase, on the basis of optimism, Mr. SETHI understood or believed that he was going to make a profit under certain business ventures with individuals behind my client's company, and that he therefore has taken the risk of entering into this contract by assuming that he would make a profit somewhere else, which would enable him to service the interest charge on this loan. It was admitted by my learned friend that he was in a poor financial situation, so in those circumstances it seems to me it's fairly obvious why there was a short-term loan with a high rate of interest is being advanced. Mr. SETHI clearly needed the money, and he has on the faith of and taking the risk that perhaps an ill-advised risk, but a risk nonetheless, that he believes that certain other business ventures will bear fruit. He has simply taken the risk as to where payment for this loan is going to come from. There is no link between the joint venture or the partnership or whatever it is that's alleged. And I don't mean to be facetious, but I struggle to understand quite what is said in relation to the previous business arrangements. Whatever those amount to, they have nothing whatsoever to do with this loan. Now, it's said that he only entered into this loan because he thought those other business interests would bear fruit. Well, my lord will be well aware the subjective intentions of parties entering into contracts are not a relevant matter for this court. That is not a legal defence to the claim. In fact, the best that can be said about the matters that have been put forward to you is that they may, if proved and if established and if substantially further explained, it is possible that Mr. SETHI believes that he has a claim against my clients. And I've explained in my skeleton argument that that's not good enough to amount to a defence. I took you to the authority of the industrial group. If there is a counterclaim, and a counterclaim has not been pleaded, if there is a counterclaim, it will only amount to a defence for the purposes of this test, a defence which would entitle the defendant to set aside a default judgment, if the relationship between those claims is so closely connected that it would be effectively unjust to try them separately. Now, I say that the defendant has fallen far short of showing to you that there is a relationship between this simple commercial loan agreement and all of the other background that she puts forward, that they are so closely connected that it would amount to a defence to this claim. And I say that partly because, Judge, if one stands back and asks what the effect is, if you accede to my submissions and you refuse the default judgment being set aside, my clients have judgment on the loan. There is absolutely nothing whatsoever to stop Mr. SETHI, if advised by Ms. Tung and those instructing her, there is nothing whatsoever to stop him from bringing a claim against my clients in respect of all of these matters, this partnership, Zilly, CVS, all of these matters that we've heard about, which may, of best of peripheral relevance, all of this background. If there is a claim there for loss of profits or for loss of rent on the villa or whatever it is that's said, if there is a claim there, that's a claim that Mr. SETHI can bring. This default judgment does not prevent him from bringing that claim, but it is not a claim that amounts to a defence to this loan. And in my submission, you should not be confused or bamboozled by all of this background. It is simply a distraction from the fact that there is a very simple loan agreement which Mr. SETHI has not paid, and he's now seeking to do whatever he can to raise whatever arguments of whatever tangential relevance to try and distract this court from the simple fact that there is a loan agreement that is due, that has not been repaid for over a year, and in respect of which he has no good defence. If he wants to sue my client and bring these other claims, then that is perfectly open to him to do, if those are matters within the jurisdiction of this court, which has not been established. There is, as far as I can discern, the facts that are set out may well not be matters falling within the jurisdiction of the DIFC courts, but that, of course, is not something that I can give further guidance on to this court, because they simply have not been pleaded out or explained with any particularity. It is not good enough to simply say, here are a load of background reasons why this is complicated. The defendant had to say why this was a defence in law, and he has failed to do so. Finally, Judge, I do just want to emphasise, under 14.2 and 14.3, it is relevant. This is a discretionary jurisdiction. You have a discretion to set aside the default judgment. You're not bound to. And it is relevant to consider whether there is a good reason for allowing this defence to go forward, and also by Rule 14.3, for you to consider whether the defendant has acted promptly and and I would say also in compliance with the court's procedures. Now, we do say that it's relevant for you to take into account Mr. SETHI's conduct. I don't intend to hyperbole when I say that this application has been conducted with complete disregard for the proper rules and procedures of this court. I've already shown you that the acknowledgement of service was not filed, despite the registry's clear direction. It has never been filed. The defence statement that is relied on by my learned friend has also never been filed or served on my clients. The respondent's skeleton argument for the last hearing was not filed and was not served on my clients. Judge, you of course recall that at the last hearing, Mr. SETHI made a very late application to adjourn the hearing, which was again not filed, was filed but not served on my clients, and which we only had notice of by logging into the court portal. We were told at that application, Judge, you will recall, that Mr. SETHI was in the process of instructing Baker McKenzie, Habib al-Mullah, who of course have not come on the record. There's been no change of representation, albeit that Ms. Tung has been appointed with requisite rights of audience to appear at this hearing. So it appears that, in fact, what was feared by my clients at the last hearing has come to pass, which is that that was simply a delaying tactic to push this hearing off by another 3 weeks. Then those 3 weeks have passed. Less than 48 hours before the hearing, again, Mr. SETHI has tried to put forward substantial additional evidence, which, as I've already taken you to, is well out of time, in breach of the relevant rules, and further in breach of even professional courtesy by not being notified to my clients. No suggestion was made within those 3 weeks that there was any difficulties or any reason to file additional evidence, no negotiations or anything like that. And it was not filed correctly until Ms. Tung simply indicated in an email that that witness statement had been added to the bundle. The registry quite rightly said that, directed that there was no permission to file that new evidence, and that permission would have to be sought. Ms. Tung sent an email setting out why permission should be granted, and the registry again wrote back and said that a proper application under Part 23 had to be made with evidence and put forward before the court in the regular way in order to bring that application before the court. Now, I emphasise all of this, Judge, not because I seek to rake over ground that we've already covered, but because I consider that it is relevant to your discretion that an applicant that comes to the court who's seeking the indulgence of the court by virtue of the fact that he has failed to comply with the original deadline for acknowledging service, it is incumbent upon that applicant to do what he can to show that he is willing and able to abide by the court's rules. And yet at every turn, it seems that in the prosecution of this application, Mr. SETHI and his lawyers have singularly failed to comply with the due processes and rules of this court. And that is a matter that you can fairly take into account as to whether he should be granted this indulgence. We say that there is no good reason why the acknowledgement of service was not filed in time, and there is certainly no good reason why, since that time, none of the due processes of the court have been followed. Finally, Judge, to the extent that it is relied, it hasn't been pressed, but to the extent that it is relied on by my learned friend that Mr. SETHI acted promptly in bringing his application, we would say against that of course, he made his application in September, but since then he has sought to introduce a whole raft of new arguments and new reasons and new evidence that were not put forward before this court promptly, that were in fact put forward but at the 11th hour, even after the first hearing was adjourned. And so we say that he has not, under 14.3, he has not brought this application promptly, and that's a further reason why this court should not exercise its discretion in his favour. My Lord, I'm conscious that there was a lot of points raised by my learned friend in her submissions, and I may not have covered all of them. So if I can assist you further with any queries. Judge, I can't hear you. I don't know if you're on mute or if it's a problem with my audio.
Oh, no, you're absolutely right. I was in a mute mood. Yeah, so thank you very much for now. I will turn on now to Helen Tang. Are you there?
Yes, sir.
Okay, I can hear you, but I can't see your picture. But yes, I can see you now.
Yes, so I have taken instructions. So the loan agreement would have been paid from the business profits. So that is the link to my learned friend's question. How was he going to pay for this? He was going to pay from the business. And I emphasize, sir, the witness statement, the second witness statement is 8 pages, and it does provide further details, as I mentioned before, that was labeled in the defense and also in the first skeleton argument. In relation to the actual loan, I have taken further instructions, and the loan, actually, the loan amount was 4.7 million, which is equivalent to the 1.2 million, which my understanding was Mr. SETHI added about 300,000, I believe, dirhams as interest till the 3rd of September, the check date, and that they asked it as an additional amount up to the 3rd of September. In other words, the interest for up to 3rd of September would have been accounted for in that. Those are my latest submissions on that. In relation to the loan at the time, or the banking, my client has said that for the villa, every month, he has, I believe it's 250,000 dirhams he has to pay every 3 months. So every month, I apologize, every month. And Mr. SETHI was fully aware, as the tenant sitting there, living in the house, knowing full well he's paying half the rent. So there's a deficit of 1.6. Now, to assist you, so if we go back to tab C4, to answer the question, what is the relevance of all these other businesses in relation to the loan? If you look at C4, paragraph 13, the defendant is the defense says the defendant is entitled to the right of set-off to the tune of about 10 million. And we list Zilli, 1 million, ZVM, as I already mentioned, about providing sand for ADNOC, 85,000 USD, rental loss, the free rent, the total loss. You will see all that. And where does it apply in the rules? If you look at paragraph 17.33 of the RDC, defense of set-off, I'm literally reading it, is where defendant 1 contends he is entitled to money from the claimant, and 2 relies on this as a defense to the whole or part of the claim, comma, the contention may be included in the defense and set off against the claim, whether or not it is also a counterclaim. So I just want to make sure it is available for the client as a defense. Now,
were you reading 16?
Sorry, it's defense of set off in 17.33 of the DIFC rules. 17.33. And I should also mention in Mr. SETHI's witness statement, he's emphasized, and again in the current instructions, is he wishes for an independent expert for the set-off, because knowing full well, as I've taken the instructions, that the loan amount was to pay from the business profits, i.e. I spent all this time talking about Zilli, ZVN, this is the relationship with the, that was how it was intended to be paid off. And so I want to end by talking about public policy and touching on the point of promptness.
Before you go that far, I mean, let me understand this one point. Let's say what I'm saying, Mr. SETHI, we're doing something to please Mr. Cynthia, the claimant, the claimant, and to help him getting into a very successful business. Okay. And one of the things that was, he agreed to take a loan with a higher interest. And now the house rent, the house rent is, and again, is another treatment by the defendant to the claimant to help him to get into the business. So I would understand if you argue this way, but if you say, but the rent can be considered as something related to the repayment of the loan, is something I do not understand at all.
Yeah. So it's my understanding of the situation is, look, if I am for example, if I am Mr. SETHI and I say, look, I'm going to engage you in these businesses. You have already got the rights of license, exclusive franchise from Zilli to sell clothing to the royal family. That was the anticipation, and there are evidence to show the ambition of the business. We can do it together. Yes, you invest 2 million, I invest 2 million. Now it was my rental. Why don't you half my rent? That was the basis.
No. The rent is to invest or to take a loan?
No. Sorry, let me just take further instructions, please.
Yeah.
So I took instructions. So the rental, let's treat the rental. The rental is his form of cash flow. So when Mr. SETHI said, we're going to do business, you're going to profit 800% anyway on CBN, why don't you half your rental? Mr. SETHI believed that. Believed that and gave him the benefit of the doubt on the rental. But that was his cash flow. It's not got anything to do with the loan. Of course, if we were to look at the bigger picture, he has to make repayments of 250,000 per month. Then of course the decreased rent does impact that, but obviously there's other factors involved. Does that answer the question, sir?
Let's add more confusion to it. Well, I'll tell you what, that's how I look at it. I mean, well, if I want someone to please me with a business or to put before me a great opportunity, I might try to treat him. So one thing I would do, maybe I take a loan from him with high interest. Another thing to encourage him, where I'm giving you half of my house rent. Okay, but all of these two things are in favor of convincing him, letting me into or giving me a bigger opportunities.
Sorry, okay. I'm just taking instructions. It's for, okay, so the rental is for his cash flow, and if the deals went through,
yeah,
he would not have taken the loan. So the loan was on condition of the businesses that were happening.
The businesses, but the rent is not businesses, isn't it? The businesses is the other business, the Abu Dhabi business, is the sand.
Two businesses, yes, the Zilli and the CBN. So when you look at his losses in terms of his defense, if I may just C4, he's put Zilli, he's put CBN, rental loss, free rent, the damage. Damage is in a different court, so we forget about that. He's only claiming for the rental loss, the business on the Zilli and on the CBN. These three. So
I understand. I completely understand what you say. Yeah. Okay, but what I'm saying, one cannot imagine that the rent is something to do with the loan. But what you can imagine, both the loan and the rent. This is if I want to follow you to the highest of your submission. So the rent and the loan is a step forward to get into the businesses, and the rent and the loan does not cover each other, so they cannot be a set off. Maybe they both can be set off against the business, but the rent, and I can't imagine how the rent would be available as a set off against the loan. If you can explain this to me, I'll be very grateful. In short.
Sorry, sir, just hold a moment.
Yes.
Yes, sir. So my client has explained it this way. He, in essence, has had an annual rental, okay, of losing, okay, from lowering from 2.8, 3.6 to 1.2. 2.4, sorry,
2.4 to 1.6.
So 2.4, as a gesture to show the trustee in London in goodwill in doing this business with Zilli and ZVM.
Right.
So I guess what I'm trying to explain, sir, it is complicated enough for the matter to be heard at trial. Because at this point in time, as you can imagine, I'm also seeking instructions as we speak. And that there is evidence to show such details, sir. If I may, I would like to move promptly.
Well, Sissy, it's not a matter of confuse if you cannot convince. It's you need to show me there is a realistic defense available to you.
Yes. There is evidence.
Ms. Tang, it's not helpful to you to tell me, oh, this is complicated enough. You need to make it very clear to me. You have a right of set-off against this loan, a very tied up link between the two things, between either the businesses and the rent. And I know the rent is the bigger factor, that because it's involved a bigger amount that you, according to your differences, either the 1.6 million and either the 6 months free rent and then the damage that happened to the villas and things like that. I know you're linking all of it.
Yes.
So the set-off generated from the rent is, I guess, so far is maybe the highest things that you're claiming in your defense and in your evidence. That's what I said, why it's important to show me where that should be available to you as a set of defense.
So I want to emphasize on the defense.
You're getting my point, is that right?
Yes, so I do understand. Thank you very much. On the defense, on the witness service, if you can just imagine for a moment, as a landlord, he was taking in sums of money in the millions. And when the rent was halved, it actually basically had created issues for his, let's say, cash flow. And also in relation to the business discussion. So the idea was you take out the loan, because we're in discussion with business in relation to Zilli and CFM, the profits from the business would then pay for the loan. So that was the idea behind it. And of course, at the time, Mr. SETHI was his tenant. They had a relationship of a kind. So it's not purely a loan agreement with no attachments. Also, Mr. SETHI saw Mr. SETHI's situation. So I want to now also, if you don't mind, sir, I want to bring onto the point about public policy, which I believe is very important to my learned friend's point about promptness. I started my submissions at the beginning to talk about the impact of COVID-19. I've just taken instructions. Mr. SETHI suffered COVID-19 and the symptoms of body illness and the cough for about 2 months, and he currently still suffers from the symptoms. He's not, as it were, diagnosed back in October, but the symptoms still exist. So I submit, sir, that the reason, and in taking instructions, he said to me he couldn't do anything during COVID. During the diagnosis, he just rested. That's all he did. So the fact that somehow he managed to get his lawyers to even submit anything, as I said before, sir, it's just how I want to emphasize.
You're missing the point. When I discuss this with you, I told you at the beginning, I'm taking your defense as the highest, as hypothetically, I'm accepting your new submission and the new, hypothetically, a new submission, a new evidence. And I say, you still need to show me the link between these businesses. Just didn't go. And that is something I will deal with it later, the matter if I'm allowing your evidence to come now because of his illness or something. Didn't tell me because of his illness there's going to be another evidence. I hope this is what not you trying to say. There's going to be new facts, new evidence, new submission because he's still suffering.
Yes. So if you want me to take you to second witness statement, maybe that will help. The witness statement.
Didn't take me. You didn't have to take me. I said all things you need to tell me.
What I want to emphasize is the link is there.
Yeah.
The link is there. He would not have taken out this loan were it not for the businesses. And it's because of the businesses, the intention was to take out the loan because of how he would repay from the business profits, and that is why in his defense he would like a set-off. The set-off of the loan amount, the set-off of the business, as it were, failure or the business losses that's been incurred from the two businesses. So,
well, so you're putting another case which that involve a much bigger umbrella contract where you could not put its term and condition straightforward, and then you say where this loan lie, what is the loan position amongst that a bigger umbrella contract. So that contract need to be approved as well. A term and conditions need to be presented, even in an implied way. And I think that's a very high threshold you're putting yourself in, Mr.
So the argument here is that there is a case to be tried, and that there are other reasons why for setting aside this default judgment, because as I mentioned before, it is not a straightforward default judgment. The timing of the discussions, the loan, the formation of the loan, which I emphasized earlier, so is very important. And also, may I also say, you know, Mr. SETHI has suffered a lot over the last few months. His health, he's lost a tenant. In terms of his business relations, as we know, COVID-19 has impacted a lot of businesses. And so I would say, sir, the opportunity to have his side heard and to have the matter tried properly and to have, I would submit with the permission of the court, a counterclaim is also important, I think, in the interests of the overriding objective and for this matter, sir. So,
can I ask you this? I mean, just imagine this court rejected your defense in regard of the other business and the rent. They would be available to you another case, isn't it, to sue the claimant NS for the loss of business opportunities, and then damage and reduction of rent and damage to the house, and let's say the consideration to the 6-month free rent as well. Would they be available to you?
well,
Another forum to bring a case against NS?
Yes, though at the same time, I believe it's also within your capacity to, of course, deal with matters expediently. So in essence, we could have parallel litigation in a sense, but at the same time, if they're related, then why not hear them together? I think that's where Article 14.2, my understanding is, if it appears there is some other good reason why the judge either set aside varied or the defendant should be allowed to defend the claim.
Yes, that might be right if these two claims have got a very strong connection, and then it would be very difficult to try each of them. With disconnect to the others. Well, I think I've heard your submission.
Thank you, sir.
Good judgment. Thank you very much. Ms. Hurst.
Judge, I don't want to take up your time with too detailed a reply. Just one point that I would emphasise is that the changing nature of the case that we're trying to meet. Your Lordship heard how many times Ms. Tung has taken instructions to try and answer what in my submission are in fact very basic questions about how the matters that she puts forward amount to a defence in law to the claim. The short answer, and I'm sure, Judge, you already understand this full well, that none of the points and the arguments that have now been developed were at all set out in the defence statement. None of these legal points have been explained. The basis keeps changing. There have been suggestions of implied terms, there's now suggestions of umbrella contracts. None of that has been explained and none of that has been set out. And in my submission, you can be cautious about the likelihood of success of a defence when the defendant doesn't seem to know what that defence is and is grasping at every possible straw to put forward an argument that might land with the court and that you might think has possible prospects of success. It is not a proper procedure for my learned friend to simply invent new arguments during her submissions which haven't been prefigured the application to set aside has to be assessed on the basis of the application and the evidence, neither of which have put forward these arguments about umbrella contracts or implied terms. In any event, my lord, dealing with them as best I can, as you rightly identify, that would be an extremely high threshold to meet. Mr. SETHI would have had to have explained what the discussions were between the parties, what was agreed, what conversations and agreements took place, which led to an agreement that the proceeds of X would be used to pay Y. That's nowhere in his evidence. And in my submission, because it never happened, Mr. Serrano is quite clear about that. I don't think it's profitable for me to respond in detail to those points, simply because they're not prefigured, they're not pleaded, they're not properly argued, and they're not properly arguable, because there simply isn't the evidence. My learned friend says that, well, if these things are related, why not allow them all to be tried together? And we say there's no good reason to do that where there is clearly no defence to the loan. And in any event, my learned friend has not satisfied you that all of the points that she alleges, contracts and so on and so forth, would even fall within the jurisdiction of this court. She's already told you that the damages, part of the damages, are subject to a separate claim. That's before the courts of England and Wales, as I understand it. We don't even know if this court has jurisdiction over the matters that are now put forward as possible defences. In my submission, it's clear that all that the defendant is doing is coming up with any point or any argument that he can to stay off the inevitable. And the inevitable, I'm afraid, is that he's entered into a loan agreement, a commercial agreement, where he has taken the risk, as businessmen do. He's taken a business decision that he will, on the hope of making profit on certain business ventures, that he will that he needs to take out this loan and wants to, I think the phrase used by my learned friend was, show goodwill by deducting the rent. Now that's showing goodwill is not a defence to the loan. That's not a term. That's not a condition or a reason why the loan isn't payable. That's simply a goodwill gesture. That's nothing to do with the loan. So in my submission, interesting though all of this is, it's simply a story that has very little evidence, very little basis in the documents, and almost no basis in law or in the pleaded defence that's been advanced. And in my submission, you are entitled to reject it. If what Ms. Tongue says is correct, she will be able to bring another claim. So there is no injustice to her client. But there is potentially very great injustice to my client. If one bears in mind that this loan has been outstanding for over a year, my clients have the benefit of a judgment. There is a stay of enforcement while this application goes ahead. If my clients are put to the cost and expense of a trial, and bearing in mind, my lord, that these proceedings have already been costly because of the way in which the defendant has conducted them, bringing late applications, late evidence, new points, not sticking to timetables. If that is then taken forward into a long drawn-out trial, and it then turns out, after great cost and expense, that in fact the loan agreement was due and payable, my clients have no comfort as to the financial position of Mr. SETHI. He has already failed to pay the loan. My clients have no comfort that they will be protected for the costs of having to defend long drawn-out proceedings. And in circumstances where there is no realistic prospect of the defendant succeeding in those claims, there is absolutely no reason for them to go forward. My lord, unless I can assist you further on any of the specific points, your lord has my submissions.
Well, thank you very much, Mr. Hurst. I think, yeah, we came to the end of this hearing. I have here a and what in my assessment is enough about both the set-aside application and even about the application to submit new evidence. Only things I can say now, I will reserve this both application for judgment on merit and cost. You'll be notified by the registry in the due course. Thank you very much.